Jun from Tsinghua University will then present his position. What we've asked them to do is to present their positions in roughly 20 to 25 minutes of sort of a formal presentation. Then we will have some dialogue among them, and then we'll go to the floor. But we're going to end by 12:40. So when you have a question, we will try to be as concise as we can. Let me just review their backgrounds, which are on the bio sheet, but I think it's important to note that Nguyen Thi Lan Anh is the Vice Dean of the International Law Faculty at the Diplomatic Academy. She's taught there since 2000. She teaches public and international law and has specialized on the law of the sea and international dispute settlement. She's a member of the research program of the Diplomatic Academy, and she received her bachelor's degree from Hanoi Law University and a Bachelor of Arts in International Relations from the Diplomatic Academy, and a Master in International and European and Commercial Law from the University of Sheffield in the UK in 2004. She holds a Doctor of Philosophy degree from the University of Bristol and got that in 2008. So she has a very diverse background, and we're very pleased to have her. Professor Zhang is an associate professor of public and international law at Tsinghua University in Beijing. His research interests include the law of the sea, the international environmental law, non-proliferation questions, and he's been executive director of the Center of the Law of the Sea Study at Tsinghua, and he's a member of the International Law Association and participates also in legal principles discussions dealing with climate change. So he, as well, is a very diverse person. Given that the projection is low on this screen, Professor Zhang and I are going to move to the side while Professor Lan Anh speaks. Then we'll alternate, and then we'll go back to our seats for the discussion. So.
First of all, thank you, Mr. Chairman, and thank you, the Asia Society and the Lee Kuan Yew School of Public Policy, to invite me for a very important event today. And the topic of the panel is the origins of the South China Sea dispute. This is a very broad topic, and I try my best to summarize the 5 main groups of the causes of the dispute, namely the colonization process, the legal factors, economics, geostrategics, and dogmatic factors. For the first factor, the colonization process, I mainly address the 2 main causes from the practice of the colonizer and what I call is the vacant status at the end of the Second World War. Before the entrance of the colonizer into the regions, littoral states, including Vietnam and China, have certain practice in the South China Sea. China may perhaps know the existence of the South China Sea through a very popular Silk Path. And the Chinese fishermen also believe that they frequently use the parasol and the spratly as a shelter when the bad weather. Also in Vietnam, the federal state of An Nam have conducted official activity for exploration and exploitation of the resources in the parasol and the spratly. And one of the king of the Vietnamese federal state even came to visit the parasol and hoist the national flag there. But unfortunately, all the practice of the littoral state have been known to the colonizer. When the colonizer came to the regions, they left some footprint and, of course, some declaration on the sovereignty issues. First, it is the discovery of the United Kingdom when they arrived in the North Borneo. Do you know why the Spratly named the Spratly? Because the captain of one of the first vessels visits the Spratly, named the Spratly. And the French also left their influence. They made the official declaration on sovereignty of the parasol and 7 group of islands in the Spratly in 1933. In 1933, Qing dynasty realized that it is a sovereignty declaration. Then 2 years after that, they sent an opposition. their opposition based on the fact that the Qing dynasty and the French have a land boundary agreement, and based on that land boundary agreement, a certain part they deal with the maritime area just outside the land boundary in the Gulf of Tonkin. At that time, French offer arbitration. Surprisingly, that offer came quite early, but of course, Qing dynasty refused. And then, together with the Second World War, Japanese came down to the south. They occupied Taiwan, and they also occupied part of the Paracels. At the end of the Second World War, we have the San Francisco Conference. At that conference, the Prime Minister of the South Vietnamese government officially declared their sovereignty over the Paracel and the Spratly. And according to the secession of Russia at that time, Russia suggests that the sovereignty of the Paracel and the Spratly should be handed over to China. And 46 among 55 participants in the San Francisco Conference rejects that idea. Although not participating in the San Francisco Conference, the foreign minister of the PRC at that time, Zhou Enlai, have stand the opposition by saying that the Paracel and the Spratly have to return to Chinese territory. So by all of the arguing, the Article 2F of the San Francisco Treaty just ends by acknowledging that Japan renounced all the title and the sovereignty over the two archipelagos, but didn't say anything more. Vietnam will interpret that without saying any word. All the valid occupation and declaration by French will continue to have an effect. China will interpret that it is not effect, it is not valid, and they would like to annex the two archipelagos to their territory based on the occupation of Japan. And the Philippines interprets this situation as a vacant situation by calling the term of art terra nullius, that the piece of land belongs to no one. So that is the end of the first causes that I believe that by the influence of the colonizer, the dispute have arisen and become more complicated. The second causes for the dispute is the legal factors. With a kind of territorial and maritime dispute like the South China Sea, at least there are three sets of rules governing the dispute. The first set of rules concerning territorial acquisitions. The second set of rules is the law of the sea. And the third set of rules is the rule to settle the dispute. With regard to the first one evolved through customary international law. I just put a list of several cases that are relevant to territorial acquisition in international law. Unfortunately, these cases developed by Western culture, Western country that belong to some accusation. It's not familiar to the country in the regions. That's why, for example, China believes that the activity of individuals like fishermen can contribute to their sovereignty claim. That's why even the Vietnamese king can hoist their national flag, but they fail to publicly declare their sovereignty to own over the world to fulfill the procedure of sovereignty declaration. That's why the Philippines can interpret as terra nullius and put their claim on sovereignty in the Spratly. And to the law of the sea. The law of the sea in the 1970s undergo through a very significant development of the third law of the sea conference. And by that conference, the little state entitled to generate 200 nautical miles of exclusive economic zone and continental shelf. And through that conference, the country realized that a small feature in the middle of the sea can have a significant effect. For example, a point in the mid-ocean, if it can have the claim only 12 nautical miles, it only generates 452 square miles. But if it has 200 nautical miles of exclusive economic zone and continental shelf, the thing is changed differently. They can have 125,600 square miles. It's multiple, a big number. That provides the motivation for certain countries to lock their claim to a small island in over the world, not only in the South China Sea. And according to UNCLOS, littoral states also have the obligation and the right to inform the Commission on the extended continental shelf limits that they have extended continental shelf. It is a kind of obligation and it have a clear deadline. That's why in 2009, we can see that Malaysia, Vietnam, Philippines, and even China submit some extended limit of the continental shelf or information. And this is another causes that some can blame that it is a new development for the dispute in the South China Sea. But in fact, it is an obligation under UNCLOS. And also, according to UNCLOS, there are certain ambiguous terms of art about historic title, and it may encourage some of the claimants to lay down the 9-dash line. Of course, the 9-dash line cannot fully interpret under UNCLOS, but in a way that we can listen in the previous panel that Professor Charles have provided us the information that it's very difficult to harmonize the law before UNCLOS and after UNCLOS. And finally, with such a very complicated dispute, there are no compulsory dispute settlement. Sovereignty issue will be opted out without the consent of the party. And up to now, we haven't had such consent of the party to give the dispute to any adjudicate methods. So that's why all the kind of law seem not really helpful, but also create a cause for the South China Sea dispute. The third factor that I would like to mention is economic factors. Here, the South China Sea is quite famous of possessing the hydrocarbon resources, fishery, as well as a very strategic navigation routes. Very recently, in February, the EIA of the United States just published the information that the South China Sea possesses a very big and significant amount of hydrocarbon resources, even bigger than Europe. And the Spratly Island alone can contain significant deposit of undiscovered hydrocarbon between 0.8 and 5.4 billion barrels of oil and between 7.6 and 55.1 trillion cubic feet of liquid gas. So all the information is quite attractive amid in the situation that all the countries in the region is a very dynamic economy and they need energy to fuel their development. Fishery is also one of the strengths of the South China Sea. The South China Sea is believed one of the richest fishing grounds in the world. Annually, it can provide 7.5 tons per kilometer of fish for littoral state. It can provide 25% for 500 million people in terms of protein for people in littoral state. That's why it's no wonder that many countries in the littoral state become the leading industries fishing in the world. And of course, China becomes the first one. In terms of navigation route, it is also containing the report of EIA that the South China Sea can provide a very strategic navigation route for many countries, not only in the South China Sea, but also outside the regions. For example, Japan, South Korea, and for the United States to some extent. And the fourth causes that I think can bring the causes to the dispute is the geostrategic factors. Because the South China Sea can provide the ocean asset for the littoral state, because the South China Sea accounts for a very significant role in terms of security, and because the South China Sea can be a sphere of military competition as well as a sphere of competing influence. All to all, it can add on another causes for the South China Sea dispute. Let's look at this map. You can see this map is highlights the land territory of China, and there are 9 exits to the sea for China. But the first 5 exits is contained by the third chain of islands that under control of Japan and Taiwan. So the 4 other exits is the only way for China to go to the sea through the South China Sea. And that's why China put a strategy of the 2 islands to chain of islands, the first one and the second one, in order to assert the ocean, in order to prove its navy strength, it have to break the 2 island chain. By which way? First, by developing the naval forces. And here you can see that the term of art about a kilo, a missile, or even many types of vessel is not unfamiliar with us nowadays because of the increasing military expenditure in China and other Southeast Asia countries in the South China Sea. Nowadays, if you read the news in the regions, you can easily catch the news and catch a picture of a military equipment. Maybe it's not good or not bad news for the US, but it's a bad news for our state in the regions. And where all the military equipment was deployed. If you look at China, they have North Sea Fleet, East and South Sea Fleet, and the South Sea Fleet, especially in charge of the South China Sea. That's why we can see that more frequently exercise, more frequently visit of the naval ship, of the other paramilitary ship in the South China Sea. What is the dangerous? Of course, it can, firstly, obviously, can increase the incident at sea, and further, it can imply that the dispute is escalating by the way that some countries try to enforce more jurisdiction, more exercise in the South China Sea. And of course, the South China Sea is not important in terms of security for China. It's also important in terms of security for other littoral states, because other littoral states, being at the small state and being as frequently attacked by the other country by the sea. So it's very important to protect security interests by maritime route. And of course, the United States have some part in this way. This illustrates the old deployment, military deployment of the United States. But taking changes for the situation, now we have the yellow arrow to show the new deployment. And all the new deployment can show their rebalancing toward Asia Pacific. And it's coincident that it matches the exit to the sea of China, and it caused some tension. Finally, domestic factor. How domestic factor can cause the origin for the dispute? First of all, because of public opinion that we just said not long ago in the first panel. It's also caused by the changes of the leadership and political cycle in the regions. And lastly, it's caused by the proliferation of national actors in charge of the South China Sea. If you look at this picture, you can easily see that public opinion is highly interested in the South China Sea. Nowadays, when we talk about the South China Sea, it may be the best way to attract, like, or view on electronic newspaper. And it's also a very popular topic for sporters to talk about, to discuss about. And of course, territorial issue is very sensitive and very important and reach the bottom of the heart of anyone in any country. But of course, it has two acts, like Professor Jones has said. On the one hand, if you too much public opinion, the leader can be captured themselves by public opinion and cannot easily make concession. On the other way, public opinion may be used as a way to detract a domestic factor to other legitimate, interesting attention of public opinion. For example, there suspects that there's some connection between the shocking Bo Xilai case in China and the running for power in just before the 18th Congress with the rising tension in the South China Sea. They also can see that there is a sharply difference between the Aquino administration with the Arroyo before, because Arroyo was accused of corruption in the South China Sea policy. With the changes of the leader, new leader come, new policy, and sometimes they make use of the South China Sea to get more support. You can see very strong word from Abe in Japan at the moment, and it is a new move. And lastly, we are quite familiar with the Night Dragon. The Night Dragon is just an illustration of how many actors can place in the South China Sea. Especially nowadays, using the Navy forces is very dangerous. So countries tend to create more and more paramilitary forces. And all the forces have their own motivation to play an active role in the South China Sea. The active role they play in the South China Sea can just justify for their own motivation to have a greater expenses from the state budgets. But in the longer term, they may have a bad influence for the South China Sea as a whole, because if everyone tries to raise the tension in the South China Sea, then there lack of coordination and the lack of trust, increased mistrust, like Professor Cho just said before. And all of these, all in all, interconnected with each other, bring the South China Sea is one of the most complicated disputes in over the world. And forgive me to focus too much on China. It's just because China is a very important player in the South China Sea dispute. We cannot handle the dispute without China. And because of the time constraints, I cannot give another example of other claimant. Thank you very much.
Thank you, Chair. First of all, I'd like to thank Lee Kuan Yew School of Public Relations of Singapore National University, as well as Asia Society, especially Professor Huang Jing and Mr. Nagoski, inviting me here. Anyway, before going to this topic, I would like to make a disclaimer, as a lawyer usually will do. First, I'm just a teacher in university teaching international law, so what I will going to talk is absolutely those, if there's responsibility that will be mine. And further, I would like to say that now it's just the mid-time in China. I myself now is under a very strong influence of jet lag. So I would further disclaim that I can use this as a defense if there's any responsibility at all. Well, if you see the title, and then you can see that quite different from N, I'm not going to talk about these substantive aspects of the dispute. Well, anyway, Anne's presentation, I think, is very, I enjoyed it very much. It's very, anyway, we are all communist comrades, so we know very much about propaganda, so it looks very, very interesting. That's it, and by the way, as a lawyer, sometimes I will not advise my client to put all the things, evidence, in the table before entering into any serious negotiations or go to the merits of dispute in any judicial procedures. I would not advise my client to do that. So today I'm talking about rather on the procedure aspect of the dispute. So the title is setting aside disputes and pursuing joint is too long. How should I setting aside policy at crossroads? I think that as China experts, mostly here, you may know this policy, but anyway, I will talk into 5 parts. The first is introduction, something back behind the policy, and then the rise of this policy. I don't know one way to fall. And the third part is the policy in the context of international law. I will talk the feasibility of this policy in the context of international law, both in terms of UN rules as well as the rules provided in the UNCLOS. And the fourth, I will go to a little bit on the Philippines notification, but sometimes maybe it quite depends on how much the jet lag will influence me. I will shift here and there from the third and fourth. And finally, I'll give a looking forward. Introduction. So what makes my question, China, keep a distance to judicial settlement? I have a lot of lists here. I think I would like to emphasize especially on the part of the resources, the human resources in dealing with this kind. We had this problem. I don't know if our neighboring countries also, the claimant countries also have this problem. Well, I guess that the smartest people in China, they all want to make money. And that made China as the second biggest economic entity today. It made it. And you will see that's the reason why I am here today. Well, you don't get it. Anyway, but then it is possible to keep a distance. I would say there's, in general, if we talk about the rule of law, this general is it's a hard rule of general international. If that the jurisdiction of international tribunal can only be built upon consent of the parties. I don't think that anybody here will disagree with me on that point. However, the consent can be presented in different types. One of the very important factor or type is so-called compromissory clause in a treaty. Normally, what does it mean? It means that sometimes, well, the treaty will have a kind of package deal, and then the judicial settlement is one part of the deal. And if you just calculate the interest and benefit that you can get by being a membership of that treaty, and then you have to take that compromissory clause as it. That's in case, especially in the Chinese practice, and we find, as Jerry has indicated, this is a WTO. So far, China has been involved either as plaintiffs, as respondents, or the third party, about 37 cases. And so I think that China's position on this hard rule or position on the set-aside policy is not very rigid. It is flexible in the issue field of trade. However, it comes to UNCLOS. So far, we had no problem until shortly before the Spring Festival that the Philippines invoked the procedure. But before that, we have to think about it. Is it inherently incompatible with the long-standing setting aside policy to this convention? So we need to understand the history, the rise of the policy. The history, I guess, is kind of in the mind of Deng Xiaoping. He is just very smart people. So, but I don't know why he thought that way at the time. We know that in the 1978, Wang Deng went to Japan to exchange their protocols of ratification on the Sino-Japanese peace treaty. Is it peace treaty? Yes, peace and treaty of peace and friendship. He did say that as for the Diaoyu Senkaku issues, it's better to set aside for the future. Officially, that what I investigated is in June 1979, the Chinese government officially proposed through diplomatic route to the Japanese government to put aside the dispute over Diaoyu Senkaku and undertaking the joint development. Since then, we can find the practice of China in the surrounding waters quite consistent with the set-aside policy. We can see it in the East China Sea with Japan, and South China's issues. It's rapidly be stated by the Chinese Foreign Ministry as the Chinese policy on the South China Sea issues as well as Spratly disputes. And in the Yellow Sea, well, I did not see the text, but it seems it is there with North Korea. But anyway, we need to distinguish a kind of two different types of disputes. What I'm saying is the policy has its scope of its own. China never proposed to the U.S. in the Nanhai incident or the other instance with relevance to the U.S. Navy spy whatsoever. China never proposed to the U.S. that we need to set aside this dispute, never. So the policy has a scope of its own. It's only about the dispute of the space of maritime or the maritime zone. It's only that kind of dispute. I would say that there will be theoretically 4 groups, subgroups of that kind of dispute covered by the set-aside policy. The first is the territorial dispute over the islands or insular features or rocks, whatever you want to call it. The second is under the land-dominant sea principle. Whenever there are territorial disputes, then it must be disputes on the jurisdiction of the surrounding waters, including territorial sea, EEZ, and continental shelf. Third, maritime delimitation dispute arising from overlapping EEZ or continental shelf claims extending from land territory. Fourth, that is interesting, disputes arising from conflict of maritime claims based on historical title right on the one hand and EEZ or continental shelf claims on the other hand. This only exists in the South China Sea. Well, I would say, if we look at the scope of the policy, we'll need to rethink and whether this policy is in conflict with China's obligation regarding compulsory of judicial procedures in UNCLOS. If China did kept the policy alive after signing and ratifying UNCLOS, it did. So it is quite reasonable to assume that the government did so on a kind of belief. Well, you may say it is a foolish or silly belief, but there must be some belief. The first is, well, China will think that the littoral claimants, they are like-minded friends, they will not do anything. So they won't take any action. more fundamentally, as a matter of law, sorry, it's something. I hear something here. Anyway, as a matter of law, China needs to consider whether or not the policy is incompatible with UN rules concerning peaceful settlement of dispute. And also in the belief that UNCLOS actually provides safeguards even within the compromissory clause or for party states to avoid judicial procedures as for the space dispute, which are more sensible to sovereignty. So that is different from the trade dispute. And I would say that provided further that China believes that the four categories of dispute are exclusive with regard to space dispute. But, well, the lawyers always, when you go to lawyers, say, if I can put it, I can make any action in the court will definitely give you advice. Go ahead, you can do. So there must be something, relevant to the legal techniques in the context. So let's review the policy in the context of international. What I want to say is, first of all, as a general international law, this must be something.
Oh, is it your phone?
No, I just got the phone.
Yeah, sounds good.
Sounds very strange. Yes.
Oh, it's coming from your pants?
From pants? No. No idea. It's but I have taken the battery out. Okay.
Ah,
oh, it's here.
There you go.
What's that? I'm sorry. Pardon me. What is there? So my conclusion is, in general, the UN rule will have nothing to do with the policy, the set-aside policy. It will be okay for China to there's no incompatibility issues in between these UN rules and the policy, especially considering, well, there's only one thing maybe that the Security Council can decide something binding to all the members, but it's never be legally practical to China, one of the 5 permanent members. And I think it's quite obvious. Otherwise, it's not necessary to design a compromissory clause here. So now the key issue is UNCLOS context. I would say that there's no doubt that judicial procedure is compulsory to party states for them to settle the dispute. Well, of course, in the meantime, this kind of procedure is subject to certain conditions. I would like to have you look at Article 286. That is it. So here I find there's 3 conditions. The first is a condition of limitations and exceptions in section 3. And the second is only applies to disputes concerning the interpretation of or application of this convention, of the UNCLOS. And the third is only applicable when no settlement has been reached by recourse to section 1. Let's go back to the 4 types of dispute. The first type, type A, is territorial dispute, so it's nothing at all relevant to the interpretation, application of the convention. The convention had no substantive rules on the territorial status. So in that sense, that jurisdiction is such kind of claim manifestly unfounded regarding this type of dispute. Well, I look at the Philippines notification. My view is that, well, I know what Philippines want to say, but I think that I made a mistake. It is not a matter relating to the limitation and exceptions in Article 298, but it's merely a matter out of the scope of dispute. Type B, I would say the type B is always almost have the same thing as type A. However, I would say, well, lawyers will suggest that disputes concerning a baseline or Article 121 disputes over the status of insular features, that's still okay. The prima facie disputes concerning interpretation and application of the clause. But with this regard, my view is that if you want to go to ask the court to proceed to adjudicate your claim, then you must have standing. Well, that will create a dilemma for anyone who wants to invoke the procedure. That will be, you either claim for the sake of standing that you claim the sovereignty of certain features. That is under dispute. But if you did that, then you go back to the type A dispute. Or you concurrently you can lay claims of some infringement to your own EEZ and content shelf. Well, and that will, my view is that will just get it back to the type C dispute, which I will talk in the following part. I would say type C and D are more relevant to the other two conditions, especially the limitations and exceptions in section 3. So first we consider section 3. I will read, there's the article was saying one signing, ratifying, or acceding to this convention, or at any time thereafter, a state may, without prejudice to the obligations arising under Section 1, declare in writing that it does not accept any one or more of the procedures provided for in Section 2 with respect to one or more of the following categories of the disputes. For the relevance, I only cite here one category or several categories in the subparagraph A. Dispute concerning interpretation, application of Article 15, 74 and 83 relating to sea boundary delimitations, or those involving historical base or titles. The fact is that China did submit in written form to the UN Secretary, General Secretary, has appeared in the website saying that the Chinese government does not accept any of the procedures provided in Section 2 or part of the Convention with respect to all the categories of disputes referred in paragraph blah, blah, blah. So it is quite clear here, type C dispute is exactly those. So it must be excluded. But there is a controversy over whether or not type D dispute can be precluded by the same declaration. Well, I say there must be some difficulties. First is the notion of historical title has never been defined in the Convention. And second, the nature, content of U-shaped line has never been kept in a certain degree of ambiguity by the Chinese government. And then we consider another condition, no settlement has been reached by recourse of section. What I want to say is that, well, that is quite nominal. Well, the fact is that Article 281, Article 282 has no relevance to this condition. I will not go to the details, but very plausible Article 283 may have some significance on that condition. Well, shortly look at the Philippines. Well, I'll say that since in the notification, the Philippines reserved the rights to further modify or supplement its claims. So I think it's unwise to make comments to the notification at present stage. But roughly, I will say something that the claims involves the validity of U-shaped line, the status of certain submerged features, and status of certain insular features. So as I said, that the condition of Section 1 is quite nominal, except for Article 283. I don't know. It's an obligation for the parties. It's quite different from 281, 282. It sets obligation for the plaintiff. But so far as I know, the tribunal just set a very low threshold on evaluating that one. But I also noticed that Ambassador Hill also suggests that this is maybe not ripe. That was something relevant to that ripe argument. And the U-shaped line, well, I rather would like to leave in discussion. Oops. And on the features and insular features, just still a matter of standing. And finally, just very brief looking forward. Well, as a lawyer, not economist, we never will speculate what's going on in the legal suit. And obviously, as someone can help to pronounce French words, this means this is the doctrine of competence that lies on the court, the tribunal. So I don't think it's wise to say anything on that of speculation of the result. But still, I think that the fate of the ongoing dispute is still under the hand of the parties, especially the plaintiffs. If we look at the case in between Malaysia and Singapore, but that can only be done by the plaintiff's calculation of lose and what we can get from the arbitration. That is something the job should be done by international political scientists. And as a lawyer, I have nothing to say on that point. That's all. Thank you for your attention.
Okay, we've had two very different types of presentations from Ms. Nguyen. We've had a presentation that gives us historical views from a Vietnamese perspective, and from Professor Zhang, an interpretation of aspects of how the Chinese may respond to the Philippine claim. So I think given that the audience is not going to want to focus on every detail of these presentations, we need to try to provide some quick overview. So I'd like to ask Ms. Nguyen if she would like to give any general overview and reaction to Professor Zhang, and then I'd like to ask Professor Zhang whether he has any other statements to make regarding Ms. Nguyen's comments. I'd like them to just be brief, and then we'll go to the audience discussion right away. Yeah, exactly. His presentation, how it affects the way you see things.
Well, it is a very complicated presentation, even for a lawyer perspective like me, because for a large part of the 15 parts of UNCLOS, and just talk about in 20 minutes, I think it's a burden for all listeners. And I believe that there's some merits in his presentation, of course, because he tried to point out from the legal perspective why the notification of the Philippines is not valid. But in my point of view, of course, the two countries are the party to UNCLOS, and they have the right to interpret UNCLOS in their own way. And that's why we need arbitration to help to reach a consensus interpretation of certain articles in UNCLOS. And as a member of UNCLOS, the Philippines, China, as well as Vietnam have the right to use UNCLOS as far as is complied with the provision in UNCLOS. And I assume that the action taken by the Philippines is in form of peaceful methods that provided for under UNCLOS. And the opposition of China is also provided for and exists in state practice so far. But I just would like that all very beautiful arguments can be presented in the court and can be decided by the court. It's going to be more effective.
Thank you. Professor Zhang, would you like to make any comments about Ms. Nguyen's presentation?
No, I'd like to leave the time to.
Okay, let's go to the floor then. Comments. Professor Cohen.
I think we should get down to the issue. It seems to me the issue is, was China correct in rejecting the Philippine petition? There are two issues in that. Does the arbitration tribunal have jurisdiction? And if it has jurisdiction, what about the merits of the case involving especially the validity of the U-shaped line? Now, it may be on the basis of the presentation by Professor Zhang that China has a good case to demonstrate that the tribunal has no jurisdiction. But if that's the case, why didn't China go to the tribunal in response to the Philippine petition in order to have the tribunal vindicate China's argument? Is there no responsibility in ratifying UNCLOS to follow the dispute resolution procedures? The key question is historic title. Is that within or without the arbitration tribunal jurisdiction?
Okay.
To consider.
Let's let Professor Zhang respond.
Jerry, you believe it's a good case for China, even then?
Please speak loud.
Okay, you believe it's a good case for China as what I presented, even under the influence of jet lag?
No, he's not taking a position. He's saying that the tribunal will have to decide that. The question is, if there is China does have a good case, then why didn't China go to the tribunal and present its own case?
Well, I think that the procedure requirement is one thing. To get involved in some other forms is another thing. If I'm correct, that in the international the practice of International Court of Justice, there are several cases that the party simply, I mean the defendant party, simply didn't appear in the court. Well, in any way, the court in that case can still make a default judgment, and if you don't go to court, you bear the consequence. That's all. This is quite different from the case of peace agreement, interpretation of peace agreement is back to 1954 or something by the ICJ. At that time, ICJ did announce responsibility of Romania and Hungary. for not selecting an arbitrator to sit in that case. It's quite different. I mean, China will have this. You can choose. Can choose the way to be involved. It is in any way, in my view, just obligation as a party states, to follow this or to follow this judicial procedure.
Okay, let me reword the question. What is your speculation about why the Chinese government chose not to go to the tribunal?
Well, it's very hard for a lawyer to speculate the motivation of the clients. It is normally it's normally none of our business. We don't speculate our
You don't
clients.
have to speculate.
Yes.
The Chinese government made an announcement about why it wouldn't go to the tribunal. It gave several reasons, none of which appeared to me to be persuasive at all.
Okay, I get the point. It's if we look at the precedents in this international judicial process, I will suggest that China, the reason why China reject this unilateral invocation of the arbitration is simply because the case is manifestly unfound of jurisdiction. That is, am I clear? Manifestly, prima facie, no, maybe not not perfect, not because maybe. Well, I should carefully choose my words. It's manifestly unfounded, the case. The reason why I don't want to play with it.
You mean if the other side is plainly wrong in China's judgment, it doesn't have to submit its argument to any impartial adjudication. China just decides it's right, and it can reject the procedure.
Well, I would still want to try to make a difference between the merits and jurisdiction or preliminary objection. It's nothing about who is right or wrong. Well, of course, everybody would believe that it's right in the merits. Philippines would believe so. China would believe so. Vietnamese state, they also believe that it is, sufficient reasons to win the case. I'm not talking about that. I'm talking in the level of jurisdiction. If I dare to guess, is why China refused to or reject the note of avowal of Philippines as well as notification is probably because China think that the case is manifestly unfounded of any jurisdiction.
Okay, let's move on.
Yeah, Robert Beckman, Singapore. Just in response to that, but China's part of UNCLOS, and UNCLOS provides that if there is a question as to whether the court validly has jurisdiction, that question is to be determined by the tribunal concerned. So if China says that manifestly this case is outside and it shouldn't have jurisdiction, then China should participate in the selection of the members of the tribunal, and it should challenge jurisdiction. And if it would, the tribunal will then decide. It's not a question for one party to decide. You accepted a system in which, if there was an issue, the tribunal would decide.
I understand. Can I?
Yeah,
Sorry. I understand the question, but what's up to me is to distinguish the issue of responsibility to the issue of some issue in economics or behavior. What's the behavior? Some theory. What I'm more interested in the responsibility issues, which I don't think they will be the case in your question. While on the behavior whatsoever, that is out of the scope of my knowledge. I cannot make an answer on that.
Yes, here.
Thank you. This is Jeannie Nguyen with Voice of Vietnamese Americans. I'd like to ask Ms. Nguyễn Thị Lan Anh about the position that Vietnam would take, that from your point of view based on UNCLOS, what do you think Vietnam has, or the Vietnam claims part of the islands? So what rights does Vietnam have based on the UNCLOS for the sovereignty? And I also asked Mr. Giang the same questions. Thank you.
Well, based on UNCLOS, Vietnam is a quota state, so it enjoys sovereignty rights and jurisdictions in all the maritime area that can be generated in compliance with UNCLOS, including internal water, territorial sea, contiguous zone, exclusive economic zone, and continental shelf. And because of the specific geographical characteristic in the continental shelf, it already submit the extended limit of the continental shelf to the Commission of the UN about the extended continental shelf. And so far, I can see that Vietnam claim all the maritime zone in compliance with UNCLOS.
Mr. Zhang.
My government also believes that all the claims are made in accordance with international law as well as UNCLOS. Of course, there will be a difficult issues concerning interpretation and application of the relevant claims. For example, people who raised intertemporal law issues, raised the issue of estoppel, the issues of critical date. So that is no doubt that is we can have some discussion over that. But anyway, I believe that my government believe that they do the right thing, as the other countries did.
Yes, over here on the left. Would you please identify yourself?
Thank you. Thank you. I'm Mr. Lloyd from Baltimore. A few days after the Philippines formally filed a claim in the International Court of Justice, the ambassador of Spain to the Philippines, to bolster the claim of the Philippines on the islands, they gave a map of the Philippines on somewhere 1500s. And with that, why did China did not react to the help of the Spanish government to the Philippines? And number two, if China is a signatory to any international treaty, why is China not ready and willing to come out in the open and solve all the problem, all on the table with all of the signatories and all of the parties involved? Why is China so very sort of creepy by talking to each and every of these countries unilaterally or bilaterally? It doesn't bode well for China as a leader in the region. Thank you.
Okay, I'll let Professor Zhang respond first, but then I think Ms. Nguyen should also comment about what she thinks the Chinese strategy is.
Okay. First, I think that it's not Philippines did not go to the International Court of Justice. This invoked some procedures according to the Annex 7 arbitration. Second, my view is very unfortunate somehow that it is true there is a compromissory clause, and that is all. There is a lot of measures against the suspects who allegedly violate some provisions concerning interpretation of application of the convention, but it did not provide any effective measures against those who abused the legal procedures or just abuse of the rights. There's no such measures within the compromissory clause. Let me just put it very simple. If some country go to also an UNCLOS party state, go to the court and ask the court to adjudicate that according to, as a matter of interpretation and application of the treaty, not mention any provision at all, that Manila is in the dispute with that country. Do you think the Philippines will go with that country to make that claim?
Try to put on the Chinese shoe to understand the Chinese strategy with the case is a very difficult task, but I'm trying my best.
Thank
Professor Chang, I think he's very well organized to categorize 4 types of dispute for us. And if my memory serves me right, there is dispute type C and D may fall in the optional exception under Article 298 under UNCLOS. And it is a theory, a very beautiful theory of the way that China can do to protect and to oppose to the jurisdiction of arbitration. But unfortunately, in reality, in order to do so, China have to prove what kind of historical title that they have. And if I were China, it's going to be a very difficult task that I have to do. So I would like to avoid it.
No, can I have? Sure. Well, I'm very unfortunate that I'm just talked so much on jurisdictional issues, nothing about marriage. But it could be China's right or wrong historical rights or titles, but nothing matters on this compromissory interpretation, application, compromissory clause, as well as especially Article 298. This is simply different levels of arguments.
Okay. Since most of the people in the audience aren't lawyers, would you at least explain in non-legal language what are the provisions of this, quote, compromissory clause that are so important?
Well, maybe I think I need to have some extra pay on next time in other occasions. It's simply, just too.
No, but you're claiming that it's so important. So at least explain its importance.
Well, the court in the first phase normally according to the practice of the international tribunals, sometimes you divide into 2 different phases. The first is the preliminary objections concerning jurisdiction and admissibility. That is also the same in the domestic court. People do that, and lawyers always suggest that it doesn't matter whether or not you can win a case in marriage. You first go to that phase, and then if you win the first phase, then everything's okay. So it's no problem then. So concerning the first phase, the evidence is different. The claims with regarding to the jurisdiction is also different from my views or the degree of the claims is also different from those on marriage. So the court in the first phase don't need to go to the marriage and don't need to decide who is right, who is wrong. This is only, I would say some preliminary prima facie evidence will be enough to decide whether or not the court have the jurisdiction over the dispute or not. Am I clear?
Let's go first to the back and then to some people here. There's someone right near the cameras in the back. Could you identify yourself, please?
Robert Lee.
And could you stand up?
Everything you wish, sir.
Thank you.
Returning to the first question, could the reason for China's... returning to the first question, could the reason for China's conduct be simply that they want to keep all their options open, particularly at a time of leadership change?
Okay. The question was, is the reason that China didn't respond and go to the tribunal because of the leadership change in China and that China wants to keep its options open.
Change of leadership.
Yes, inside China.
I'm only an associate professor in the school. Sorry, I don't know that.
Okay, he's not willing to speculate. Okay, let's go here. Anne-Marie?
Anne-Marie Murphy, Seton Hall University. I have a question for Ms. Nguyen. You referenced the Vietnamese submission on the continental shelf to UNCLOS that was submitted jointly with Malaysia, as I understand it. Given that we have heard from Dean Zhu and others that it would be useful for ASEAN to resolve its claims within itself and then grapple with China, I'm wondering if there are any lessons from the experience of Vietnam and Malaysia jointly delineating the continental shelf. I'm not an expert on UNCLOS, but what if any lessons came out of that, and might that not serve somehow as a roadmap to resolving intra-ASEAN claims, and perhaps having some impacts for negotiating with China? Thank you.
Thank you very much for your very interesting questions. There are no secret at all, of course I can share. The reason why Vietnam and Malaysia can be successful in entering a joint development for their continental shelf based on two simple reasons. First of all, because they are quite clear in delineate their claimed borders based on UNCLOS to claim economic zone and continental shelf. And in case the continental shelf, we both agree with the claim of each other, the legal basis of the claim. And the second one is because both of us has the willing. We have the willing to shelve the dispute and go for economic benefits. And so far, I can proud to say that it is one of the most effective joint development model in the South China Sea, because the two parties can quickly enter into the agreement and have the real economic benefits.
Yes. Wait, just please identify yourself.
I'm from Greenwich, Connecticut. I have to say I don't have a lot of background in this issue, but I appreciate facts. And I know Professor Zhang was trying to somehow state China's position about compulsory clause, but I got much more confused. So I just want something simple. Like Ms. Nguyen has said, there was some success in dealing with that particular case. Is it possible to duplicate that with China? Another comment, if I may add, aside from the dispute, we all know the danger, the increasing danger of climate change. Is there any effort for all the countries in the region to work together on that particular issue before everything goes underwater?
Professor Zhang.
Yes, seriously, I think it's a very good question. It's very important. Anyway, we live as neighborhood, and we live in the globe. I think it's quite stupid to be obsessed to these disputes and ruin our relations. We need to look forward, and my view is just definitely very important, especially in the semi-enclosed sea, to have a cooperation between these neighboring countries to get things a kind of achievement.
I think for sure it can be duplicated, because like Vietnam experience, for example, we already have a fishery agreement with China in the Gulf of Tonkin. And I can say that one of the reasons why we can be successful in that area is because the claim of both parties also, once again, based on UNCLOS. And in other areas in the South China Sea, we face extremely difficult in identifying the claim, because one of the claimants not really based on UNCLOS, but based on other legal basis, but we really haven't known yet. And once we have the clarification from that claimant, we think that we have to we can work on the possibility of joint development. And also when you talk about climate change, I think it's not a bad idea. Nowadays, everyone talk about the bad consequences of climate change to the weather in over the world, but in case of the South China Sea, maybe it's lucky then. All the feature when it disappears, there's no dispute, and for sure for peace.
Okay, in the middle on this side.
Hi, I'm James Lee. I work in finance here in New York. I am not an expert on the UN Convention on the Law of the Seas, and I'm not really familiar with all the details concerning the present disputes in the South China Sea. But I just have a very basic question. Looking at the map, it just seems like it's a very complex issue involving so many different countries and parties. So my basic question is: has the UN Convention on the Law of the Sea, has it ever been used to successfully solve any kind of maritime dispute as complicated as this in any other part of the world? I mean, especially in a case involving many different parties and their claims. Has the UN Convention on the Law of the Sea ever been used, successfully to resolve a question as complex as this involving so many different parties?
First, the issues in that marine region or area that happened there, not necessarily all concerns the convention. I mean, the rock is there, but the ownership of rock is nothing relevant to the convention. So the convention has limitation in helping the claimant states solving this problem. Just happened to be there and nowhere of the not high sea, in the nowhere of the sea. So that is one of the limitations. The other is, I guess, there will. If we look at the development of the law of the sea, there used to be a lot of disputes in between the Mediterranean countries, the Nordic regions countries, and also Caribbean states. And we're quite confident to see there's a lot of successful cases or experiences to employ to help the states in solving their issues in that region. There are some.
Well, based on UNCLOS, we can find both yes and no helpful effort to the dispute. The yes, because if everyone based on UNCLOS and use good faith to interpret article in UNCLOS, I think the claim, especially on maritime claim, will significantly reduce, and we're going to have a very clear basic to move on to discuss or negotiate or settle the dispute. No, because I totally agree with Professor Chang that the sovereignty issue is another matter that governed by the law concerning territorial acquisition. And according to the principle that land dominates the sea, we have to settle the sovereignty first, then you go to the maritime dispute. Unfortunately, the sovereignty dispute cannot be settled, and there is lack of the willingness to clarify the maritime claim as well under UNCLOS. So that's why we arrive at the deadlock.
Okay, we have time for two more questions. So here on the right.
Yeah. Hello? Yeah. The title of this session was Historical Origins of the Dispute, but from what you're saying here, it really doesn't have any impact on how this dispute is going to be settled. For example, the provision, quote, the notion of historic title is not defined in the convention. And this essentially what determines how useful is it to go back to the pre-colonial period or the colonial period or 1500. In fact, it means nothing. according to this convention, which was historic title has nothing to do with it. So arguing whether China has a difficult case to make or not, Vietnam has a better case to make historically, I don't think that really plays into a solution, does it?
Do you want to respond?
It's very difficult to talk about history because we didn't live in that time and we cannot count exactly what happened in history. But one thing we can know for sure is that for sovereignty issues like territorial dispute in the South China Sea, historical still account for certain effect. And we usually talk about the early practice of a certain state or the other state, and when the court dealing with such kind of dispute like territorial dispute, they will have to consider the practice in history. However, what kind of history is it's very important to look at. For example, there is one argument that Vietnam is a tribute of China for a long time, so all Vietnam claim in the past will belong to China. And it's very interesting that I found an article read by a very critical author of French in the yearbook, the French yearbook of international law, that at that time China believed that all the tribute of China, including the United Kingdom, the Holland, some other country in Southeast Asia, and including the Holy See. So we are not the only one tribute to China. And if China go on the argument, maybe the whole world will belong to China. So we hope that that's not the legal, the historical argument that the court will go on.
Professor Zhang?
Yeah, it is kind of touching the core of the whole problem. It's sad that, Jeremy, you may disagree with me. Well, we're talking about international law. International law is something created by this Westphalia Convention, and then basically it has its origin in the Western European countries and developed in the Western world. Some people argue, my boss, my senior professor James Lee always say that now we have Eastphalia. It's quite different from Westphalia. So that makes the whole thing's very difficult and challenging the wisdom of the people within the region, whether they can settle it. In that sense, history is quite relevant. I think that people cannot live from nowhere. They must have their own history, and then they track back to their history and they find a way out from that history. We are here. We are not here from nowhere.
John, you get the last question.
I don't envy Professor Zhang's position at all, and there are tones of it that are reminiscent of the first presentation this morning, that are the attitudes of a large power that ultimately believes its power should be respected in the region. Professor Ang's conveying the views of the countries on the periphery of a large power that feel they have as legitimate histories as the large power does. As I'm hearing her in her last comment, my sense is that her view of the resolution is a mix of politics and the law of the sea, and I wanted to be sure that politics in the sense of countries deciding that it is more in their interest to have a solution than not have a solution, and I wanted to see that is where you're concluding as the way forward to pick up the topic that Dr. Zhang ended with.
Well, our government always sends a message that we would like to settle the dispute by peaceful means based on international law, particularly UNCLOS. So what does it mean? Does it mean that any measure that's peacefully will be encouraged? That means that we will give the priority to international law. But at the end of the day, who enforces international law? of course, state. And our international system is totally different from national system. We don't have enforcement agencies. We base on good faith and good relations of other states. We also base on the whole world public opinions of the right thing and the wrong things. And we believe that it cannot be separate totally from politics, of course. At least we need the good faith, the goodwill of the other party to settle the dispute. And it's not codified in law yet.
Okay. Professor Zhang, would you like to make any final comments?
Well, what I want to say is China is big. It's a big country in the region, and the other countries comparatively small. I can understand the small countries psychologically. They may have their own worries in front of big countries. I very much understand it. But I think that we need to pay more attention not on the psychological aspect, but rather on the deed that the countries have undertaken. On the matter of the Philippines invocation, it is quite interesting that the Philippines did not intentionally avoid a dispute of maritime delimitation rather than requesting a declaratory judgment, and it's obviously if we look back, the declaratory judgment in domestic law back to the 1930s in the United States, and it's still ongoing, especially on the intellectual property cases. Well, actually, given a rather weaker party who would like to, for example, in the intellectual property case, the one who don't have the patent or copyright to have this cause of action, to ask the court to do that. Well, what I want to say is quite understandable that weaker parties, they will try all their way to find a cause of action and go to the court. But on the other hand, well, it's still a matter of interpretation and application of the treaty if we go to the case.
Okay. Professor Nguyen.
I just beg for 2 more minutes before we have lunch, that I'm really proud to hear that nowadays we are under the threshold to enter the Eastphalia, not Westphalia area, and in which China play a very great role as a big country in Asia. And we believe that with such a great role, there are no difference between words and deeds anymore. And we hope that China won't pay respect to UNCLOS, the treaty that China participated in the early time to contribute in the developing and signing the treaties.
Okay, can we thank our speakers?